Facts. On September 5, 1983, then 16-year-old petitioner Luisito Pulido married his teacher, then 22-year-old private complainant Nora Argon in a civil ceremony at the Municipal Hall of Rosario, Cavite, solemnized by then Mayor Calixto D. Enriquez. In 2007, Pulido admitted that he was having an affair with Rowena Baleda, to whom he was also married in 1995. This resulted in the filing of a criminal charge of bigamy against Pulido and Baleda. In his defense, Pulido claimed that he could not be criminally liable for bigamy, since both his marriages were null and void. As for his marriage with Argon, it lacked a valid marriage license, while his marriage with Baleda lacked a marriage ceremony. On the part of Baleda, she puts forth, by way of defense, that she only gained knowledge of Pulido's prior marriage in April 2007. She later filed a petition to annul her marriage, which was granted by the Regional Trial Court on October 25, 2007. Hence, her marriage with Pulido was already annulled, even before the filing of the bigamy case. The RTC convicted Pulido and acquitted Paleta. This decision was affirmed by the Court of Appeals. The issue here is whether a judicial declaration of nullity of marriage is necessary to establish the invalidity of a void ab initio marriage in a bigamy prosecution. The ruling, the Supreme Court clarified that when both the prior and subsequent marriages were contracted prior to the effectivity of the Family Code, a void ab initio marriage can be raised as a defense in a bigamy case, even without a judicial declaration of its nullity. Nonetheless, the court recognized that an action for nullity of the second marriage is a prejudicial question to the criminal prosecution for bigamy. However, for purposes of contracting a subsequent marriage, a judicial declaration of nullity of a prior marriage contracted before the effectivity of the Family Code is necessary. Thus, Article 40 of the Family Code will have a retroactive application since it does not prejudice nor impair vested or acquired rights. Article 40 of the Family Code only requires a judicial declaration of absolute nullity for purposes of remarriage, but not as a defense in bigamy. Article 40 does not categorically withhold from the accused the right to invoke the defense of a void ab initio marriage, even without a judicial decree of absolute nullity in criminal prosecution for bigamy. The court explained that it would be unfair to bar the accused in a bigamy case from raising the defense of the nullity of his previous marriage in a bigamy case when Article 40 does not explicitly say so. Thus, in a criminal prosecution for bigamy, the parties may still raise the defense of a void ab initio marriage, even without obtaining a judicial declaration of absolute nullity if the first marriage was celebrated before the effectivity of the Family Code. Such is still governed by the rulings in Mendoza, Aragon, and Odayat, which are more in line with the rule that procedural rules are only given retroactive effect insofar as they do not prejudice or impair vested or acquired rights. Here, Pulido's marriage with Argon was celebrated when the civil code was in effect, while his subsequent marriage with Baleda was contracted during the effectivity of the Family Code. Hence, Pulido is required to obtain a judicial decree of absolute nullity of his prior void ab initio marriage, but only for purposes of remarriage. As regards the bigamy case, however, Pulido may raise the defense that his prior marriage with Arcon is void ab initio, even without obtaining a judicial declaration of absolute nullity.